why am I so orange? God, I gotta fix that. Here, let's fix that. It's so dark right here. I don't know. I kind of look orange. That doesn't look very nice. Why do I look orange? I don't know. Let's see what all these things do. Share your screen. Okay, end your stream. What all of these things do, I'm not sure. Okay. Just orangey looking. Not a good look. I really like it. I could do something different about that. Let's see. What can we do about that? I think I want somebody else to sit down. I guess so. I don't know. Go get some light. Here. Go get some light. I'm going to turn the light because it's too bright. Let's see if that helps any. I guess so. I guess it does. Okay, now let me see what else. Because I've never used this one. I'm not too sure about much, but okay. What's a pop-out dashboard? I don't know. All right, it looks like my microphone is working good. Okay, maybe I should turn it up. I'm not sure. Let's turn it up some. Make sure everybody can hear. Okay, I guess that's better. I don't know. Whoop, here we go. This will be interesting since I've never done it on here before. I don't have an intro. I don't have an outro. I don't have none of that. All right. Live. Okay, I've been live for like a minute, 38 seconds. I don't really have an outro or an intro here. This is on actually YouTube, going through that's vidIQ, but oh gosh, my hair. So anyway, we're going to start today with the Vallow Daybell brief filed by her attorneys for her case in Idaho for her children. Look at my funky hair. Anyway, that is what I have gotten hold of today. I'm going to read that out loud. We're going to kind of talk about it. Let me see if I can get it on the screen. I know it's a rough start over here because I've not done it this way and I don't know how to add things, but we're going to see what we can do. So we're going to share our screen and see what happens. Here we go. Share the screen, okay, with our brief. Share. And let's go back over here now. Now, I'm over in the corner. That's kind of funny. All right, so let me see if I can make so we can actually read this aloud. Let me see. So I'm just not too sure of what does this do. Okay, I'm not too sure about how to make this bigger and how to scroll it and all that. So just give me a second here. All right. Hey, True Crime Marty, how you doing, girl? So good to see you. Did you see my email? Because I don't think let me see if this works. I'm trying to figure out how to make this scroll down over here so I can read this. I don't want to have to get my iPad, but I will if I have to. See, I don't know how to make it scroll. Hang on just a second. I want to stay in the screen. I'm not too sure. I've never done it live from YouTube before. I've always used something else, but I'm trying to use a different streaming service. So, oh my God. Anyway, let me see if I can fix this to where I can make it stream or, actually scroll or whatever. Hold on. I'm going to stay right here, but I'm going to move this around some. Hang on. Let me fix this over here. Come on. Oh, come on. Let me put this over here. Come on. Go over there. Go over there. We're going to go down here to the bottom. Okay. I don't know how to. All right. Now, I don't know how to make this scroll on while I'm here. I'm only familiar with StreamYard. Yeah, me too. I really don't know anything else, but I'm going to try my best to figure it out. Because a lot of people talk about, like some of these other streaming services just have better quality options, and they have there's just things that they can do that StreamYard cannot do. So I had paid up front for StreamYard for like 6 months. And so once I ran that out, I decided, okay, we're going to give a good try on something else. So anyway, here we are. Now this is actually, I wished I could figure out, I might have to get my iPad, but I hope not, because stream, you can scroll down on your page here? Why can't you scroll down? I don't want to split the screen because I don't think that'll work. I don't know. Let me see if it will. Hang on just a second. But then y'all can't read along with me. So just bear with me, okay? It's always something, but that's okay. It's okay, really. Split the screen. Okay, there we are. Here's the, okay, I think I can do it this way now. Yay. So silly. I know, so silly. All right. Do you still need moderators? I'm not showing. Oh, why aren't you showing up? Oh, let me get, okay, hold on. Let me get my phone and see if I can fix that right now, Marley. Hang on. All right, yes, I still need to have you. Yes, I do. Of course I do. Let me see if I can fix that right now. All right. I'm going to YouTube. Oh, you got to go to YouTube Studio. Hang on a second. Lord. YouTube Studio. Here we go. Why is it going so slow? Every time, when you want something to work, it doesn't work. I'm so glad things are better and you're home. I'm so sorry you had those problems, but I'm glad you're back because we missed you, Have you been keeping up with all the things going on Sebastian and all these other cases right now? The Lily and Jack case is terrible. The thing going on with Sebastian right now is kind of terrible. I know that they're trying to bring Summer Wells back up, and that's good. Look at this. It just won't go anywhere. It's just like it's stuck or something. Here we go. Come on now. Let me see if I can get this to, it's just, okay. I know it works. Where we go? I'll try to go in it this way. See what's done. There we are. All right. Here's this. Here's this. Okay. Let me see if I can go back. No. What's wrong with me? I don't know. Okay. Let's see. There's that. Okay. I want to get back into my community. Oh, what am I doing? Okay. There's that. Okay. Maybe it'll go work over here now. Let me see, Marley. Hang on. Content, community. All right. There's a place on here where you can, right now I don't know where it's at. Oh, my Lord. I want to go to that spot where you can change things. I don't know what happened to it. Content. There's that. Oh, wait a minute. Maybe it's over here. Hang on a second. I need to fix it, Marley. I'm so sorry because it just doesn't always work when I'm trying to get it to work. I don't know what. Oh, settings. I think I found it. Let's see. Okay, settings, permissions, creators. There's that. Permissions. Let's see. Nope. Maybe that's not it. I'm not sure. I don't think I can do it on the phone. I think you have to do it on the computer, but I'm not sure. Help center. No. Yeah. For some reason, there's just no way for me to fix that over here, which just is terrible. But okay, anyway, after we get off our live, Marley, I'm gonna go ahead and fix it so you can have your wrench over here because you're right. I don't see that wrench, and that's terrible. It's absolutely terrible. Okay, so let me bring this over here where I can see it all the way. Let's see. Come on. That's so weird. I might have to make this one a little smaller and get. There we go. All right, that works. Now I'll be able to roll it and all that, and y'all will be able to keep up with me. Oh, yay, that does work. See how silly I am? It's so silly. Yeah. Okay, so I'm going to just there's no way we can do this all in one day. So we're going to just work on it for a little while. It's 71 pages. But what I wanted to do was find out, Marley, about what is she claiming is the reason for her appeal. The first 8 pages is all this stuff about all these. It is the technology. It is the technology, right about this. It's all the cases that they use to support her claims in her brief. So that's why I'm not going to show those first 8 pages. Okay. So I'm just going to read it out loud, and we'll just go from there. And then we can, just stop every once in a while. And all that. I'll take a drink. Anyway, you know how long it takes to do this. So if you need to do something else while I read it, you go right ahead and just listen. I'm good with that too. A lot of my stuff I've noticed people just listen to later, and that's fine because some of it is rather boring, but some of it's not. But my Justin Banta case, oh Lord, girl, wait till I get into that with you. I don't know if you watched the one about Justin Banta. Justin Banta is the guy who is in Texas, and he ordered the Plan C pills over the internet, and he slipped them into the drink of his girlfriend because he wanted her to get to not keep the baby, but she wanted to keep the baby. She was only like 6 weeks pregnant. So he slips it into the drink. She gets there. He gives her the drink, and she just drinks it. She doesn't think anything of it. And he made her a batch of cookies. Well, she did not eat the cookies while she was at the restaurant. She took the cookies home with her. And so he kept hounding her to that night. Oh, come on, take a video of you eating the cookies I made. Eat the cookies I made. Eat the cookies I made. And she said no, she really wasn't hungry. But then she ate one just to make him happy. Well, the next morning, she ends up losing the baby. And when they ran the test and all that, they tested the cookies, the baby, and everything. That's where they discovered the Plan C drugs were slipped into the food and into the drink. But the thing about that is, and I bought a movie about Plan C that I'm going to show that too after we do this one, because it was so interesting. But I found out that oddly enough, it's like anybody can order these pills online, okay? And they just mail them to your house. But one of the things that was noted in this video, which shocked me so much, if you can't pay for it, that's okay. They say just donate what you can. You're like, what do you mean just donate what you can? Then you have people that say, oh, I want to have it in advance in case I need it. I'm thinking to myself, what do you mean in advance in case you need it? Anyway, so that's kind of what that case is about. But today we're just going to talk about this thing because I want to know myself, what does Lori Vallow Daybell think she has a reason to appeal on? Because as far as I'm concerned, and I'm not the law, whatever. I think the judge did a damn good job. But anyway, so let's just go on with it. So the first page is the statement of the case. And it says, nature of this case. This is Lori Noreen Daybell, direct appeal from the district court's judgment imposing and controlling term of life in prison without the possibility of parole for her convictions on 2 counts of first-degree murder, 3 counts of conspiracy to commit first-degree murder, and grand theft, and 1 count of grand theft. Mrs. Daybell respectfully contends several prejudicial errors tainted the fairness of the proceedings in this district court. These 3 appellant issues surround the district court's mishandling early in the case of state's quest to remove Ms. Daybell's retained attorney. First, on the merits of the district court's ruling disqualifying Ms. Daybell's attorney violated her fundamental 6th right to counsel of her choice. Second, the court deprived Ms. Daybell of her 6th Amendment right to assistance of counsel at a critical stage when erroneously routed the disqualification issue into the companion case of State versus Chad Guy Daybell and did not allow her counsel to intervene in her behalf in the case. Third, the court violated Mrs. Daybell's 14th Amendment right due to due process of law when it heard and decided the issue while Ms. Daybell was incompetent. Her case was stayed and she was not present. Incompetent. Oh no, they proved she was competent. Remember that? I know y'all remember that. The district court also erred in permitting the state to present a wide-ranging, uncharged bad acts evidence at trial under Rule 404B, the Idaho Rules of Evidence, which injected prejudicial character and propensity evidence into the case. I wanted to say prosperity because that's the bank my husband, anyway, I said him with a bank. Anyway, and propensity evidence into the case. And finally, the trial never should have happened because Mrs. Daybell's right to a speedy trial was violated. The court should reverse the district court's judgment on these grounds. Okay, Lori. Boy. Let's see. Here's the statement of facts. The background from Arizona to Idaho. And so here's where they tell her story. In 2018, Lori Vallow arrived in Arizona and was married to Charles Vallow. Lori and Charles had adopted Charles's grandnephew, Joshua Jackson, JJ. JJ was born prematurely and was autistic. And then I'm not gonna name or say the cases that they're citing here because that would just take way too long. He was smart and loving, but he was also a typical 7-year-old autistic kid, meaning that he followed strict routines and had some trouble in social situations and could get upset at small things. And then it's citing things. He was not yet fully potty trained at night, and he attended a private school that had services for autistic kids. Okay, so that's, just explaining those. All right. Lori's daughter from her previous, okay, so they cited some cases, and then here we go. When appellate cites a record in Chad Daybell's companion case in the district court, parts of which have been augmented to this record on appeal, appellant will include the case numbers, and that's why all that is there to explain that. So because Chad and Lori Daybell share the same last name, appellant will refer to them by their first names when necessary to avoid the confusion. Lori's daughter from her previous marriage, 16-year-old Tylee, also lived in the home. Tylee was a smart and vivacious kid, but she could be a moody teenager. Tylee struggled with depression, anxiety, and panic attacks, and she had frequent and painful bouts of pancreatitis throughout her childhood. Tylee got her GED so that she could graduate from high school early. Lori's faith was a central component of her life, and she was a devout member of the Church of Jesus Christ of the Latter-day Saints. In October of 2018, Lori met Melanie Gibb at a church event, and they became friends. They talked on the phone and texted each other often. Another member of their circle was Zelima Pastinas. Melanie and Zelima had been routinely attending so they were attending the Preparing of People conferences. Preparing of People was a group or association that sponsored periodic conferences and events with speakers who would teach attendees how to better be prepared for anything that might happen, like a disaster, but as well as preparing, or them, for the second coming of Jesus Christ. Melanie and Zelima shared these interests in common with Lori, along with other individuals in their circle of friends. In late October 2019, Melanie, Zelima, and Lori and 2 other women drove to St. George, Utah to attend a conference. Chad Daybell from the Rexburg, Idaho, was a frequent speaker at these conferences, where he would also sell his novels about end-time preparations, near-death experiences, and other spiritual matters. Chad attended the October 2018 conference in St. George. Lori had not yet met Chad, but she had read a few of his books. Lori spent much of the weekend at Chad's table. Melanie claimed that Chad had told Lori that he had been married in an earlier lifetime or time period, that they had been married in an earlier life or time period. As part of their religious beliefs, Chad, Lori, and others believed that people had lived multiple prior lives or probations. Chad had also had a near-death experience from which he gained spiritual insight, as had Lori, and he claimed to be able to see beyond the veil. Okay. There was an immediate connection between Chad and Lori. After they met, Chad and Lori continued to contact and see each other. This was difficult. It was a difficult time in Lori's own marriage, which had started to deteriorate. Lori and Charles tried a brief reconciliation in Houston before Lori moved back to Arizona with Tylee and JJ. Chad taught the circle of friends that he could see the light and the dark in people, and then he had developed a rating scale of lightness and dark. After that, as Melanie and Zelima would testify at trial, Lori began to tell them that Charles was possessed by a dark spirit or a demon. They engaged in castings with her, or something akin to prayer circles, where they would attempt to cast out Charles' dark spirit. Yeah. Oh boy. On July 11, 2019, Charles came to Arizona to spend time with JJ. He arrived at his estranged wife's home a little after 7:30 a.m. to take JJ to school. Charles got JJ in his car when he realized that he had left his phone inside. Tylee was sleeping in her bedroom, and Alex Cox, Lori's brother, was sleeping in another bedroom. Boy. Charles came back inside to get his phone, but Lori had it. Charles got extremely upset that she had his phone. They argued, and Charles started chasing Lori around the room to get his phone. Now, remind you, this is Lori's story of how this took place. So we can't ask Charles because he's not here. So this is all what she had to say. Hearing the commotion, Tylee came out of her bedroom with a bat, which she poked at Charles to protect her mom. He took the bat from her. By this time, Alex had stirred and emerged from his bedroom to subdue Charles. Lori got Tylee out of the house and into the car with JJ. Alex claimed that Charles hit him in the head with the bat, so he went to get his gun. Now, I want you to think about this. He's been hit in the head with a bat, but he has time to go get a gun and come back. All right. He came out of his room with the gun. Charles approached him with the bat, and Alex shot him twice. Police officers would later testify that some of the physical evidence did not match Alex's version. Charles died from his wounds. Because of Charles's death, JJ began to receive Social Security benefits and Charles's surviving minor child. Lori checked into Charles's $1 million life insurance policy and discovered that it had been changed to the beneficiary, recently to his sister. On September 1, Lori moved from Arizona to Rexburg with Tylee and JJ. Alex also moved to Rexburg. Lori lived in an apartment, and Alex lived in another unit in the same complex. Lori's niece, Melanie Pulowski, whom she considered to be a daughter, came to Rexburg and lived in the same apartment complex. Melanie, who was divorcing her husband, Brandon Boudreau, was part of the same group of friends as Lori. Lori enrolled JJ in a local elementary school. Tylee had finished high school and was living at home for the time being. On September the 8th, hey, Sprinkled Donut, so good to see you. How you doing? So glad you came in. I'm so glad you're driving and listening because I like to hear that. I'm glad to see you. Okay. On September the 8th, Alex, Lori, and the kids went to Yellowstone National Park. Lori took a picture with them smiling, Tylee hugging JJ with Alex to their sides. Near someone, all right, listen to this, with Alex to the side, near some of Yellowstone's famous geysers. Oh, that was kind of dangerous. Now listen to this, because now it's going to skip from September the 8th all the way over to September the 20th. Well, what happened in between, okay? On September the 20th, Melanie Gibb and her fiance, David Warwick, came to Idaho for the weekend to visit Lori. Melanie and Lori were also intending to record a podcast. Melanie and David did not see Tylee while they were there. They did see and interact with JJ, however. They would later testify that on the evening of September 22nd, Alex came inside holding a sleeping JJ, taking him upstairs. Lori, late into the evening, Melanie and Lori recorded their podcast, with David also participating. The next morning, David and Melanie left to continue their trip. They did not see JJ. JJ also did not return to school. In early October, Chad's wife, Tammy, was in her driveway, having just gotten out of her car when a masked person approached and fired what appeared to be a paint gun at her. She asked him what he thought he was doing, and the person ran away. Within a few days of that event, someone fired a gun from the back of a Jeep at Melanie Pulowski's soon-to-be ex-husband, Brandon Boudreau, in Arizona. Well, we know who that was, don't we? The shooter missed him, and Brandon stepped on the gas. This incident also became part of the state's case at trial under IRE 404B. All right. Now, I have the 404 paperwork that they had filed and were going to use. But then in the end, they decided not to use this 404B. So I've never really showed y'all the paperwork. But I did buy the disc with it on there. But someday we'll bring it out. So then it goes on to say, on October 19th, Tammy Daybell died suddenly, ostensibly in her sleep. The coroner initially ruled the death to be natural. Chad chose not to have an autopsy completed, and Tammy was buried in the Utah within a few days. He collected the life insurance for her death. It's like they're just skipping all kinds of things. On November the 5th, Chad and Lori were married in Hawaii. In November, JJ's grandmother contacted the police seeking a welfare check because she had not heard from her grandson in quite some time. The Rexburg police contacted Lori at her townhome. She told them JJ was with her friend, Melanie Gibb, in Arizona. The police contacted Melanie Gibb, who shared that she had him, but then she didn't have him anymore. That Lori had him, like that she's sitting back to Lori. Okay. She then called them back and told them JJ had never been with her. I guess she decided she better not lie, right? After this encounter, Lori and Chad left Rexburg and went to Hawaii. In the meantime, Alex Koch had married Zulema Pastinas. He moved back to Arizona to live with her. And on December the 12th, Alex died. There is no evidence that foul play was involved in his death. Tammy's body was exhumed and examined. The coroner revised the cause of death to asphyxiation. The children's whereabouts continued to be unknown, and law enforcement intensified their investigation. On February the 20th, 2020, police officers arrested Lori Daybell in Hawaii on 2 felony charges, alleging desertion of her children, along with associated misdemeanor charges. She was extradited to Idaho to face those charges. And here comes the court proceedings. This is the next part. Okay. A, the events leading to the district court's disqualifications of Lori Daybell's retained counsel. Immediately upon her return, Lori retained attorney Mark Means as her counsel, with Chad supplying the funds to hire Means. Means entered his appearance as Lori's co-counsel in the desertion case. Means would eventually be her sole attorney in that case. Around that same time, Chad retained John Pryor to defend him against any forthcoming criminal charges. Pryor took the place of the previous attorney that Chad had retained, but who did not intend to represent Chad in a criminal case if it came to fruition. Several weeks after Means entered his appearance on April 28th, he issued a press release that he represented Chad and requested the media to please direct all requests for communications or statements of the like to his office. Okay. He posted a similar message on his Twitter account. The same day, Lori called Chad from a jail phone. In that call, Chad indicated that Mark Means currently represented both Lori and him to some extent, though Chad had told her he was eventually going to go with the other guy, meaning John Pryor. At Lori's bail reduction hearing, Means informed the judge that he represented both Lori and Chad. Within 6 weeks, on June 9th, 2020, police searched Chad's property and discovered the bodies of the missing children buried near a pet cemetery in his yard. While the search was ongoing, Chad attempted to drive away from the scene, but was arrested. Based on the evidence found during the search of the Daybell property, the state charged both Chad and Lori with conspiracy to alter or destroy evidence. They were the first criminal charges against Chad. Mark Means again appeared as Lori's attorney in her case. John Pryor now appeared in Chad's case as his counsel. So number one, the state's first attempt to remove attorney Mark Means. I guess they tried a few times. At Lori's initial appearance on destruction of evidence charges in June, the judge asked Means whether he represented any co-conspirators listed in the complaint. Means responded that he did not. The state moved that the court to deny Means entry into the case and to appoint new counsel for Lori, arguing that Means had potential conflict of interest after previously holding himself out as counsel for both Chad and Lori. In support, the state relied on the public statements that Means had made in April and May of the year, indicating that he represented both Lori and Chad. It also pointed to the April 28th recorded jail call between Lori and Chad, in which Chad suggested that Means represented both of them at the same time. Means countered that he had, at most, represented Chad in a limited capacity for a brief period before he had been charged. He reasserted that Chad had separate counsel in a criminal matter, John Pryor, who also had informed the judge on more than one occasion that there was no conflict of interest, and even if there were, it had been waived through a written waiver signed by both Chad and Lori Daybell. Means provided that the written waiver to the judge. Means further claimed that he had consulted with Idaho State Bar Counsel, who described the relationship as limited representation or having a cup of coffee with Chad Daybell, and that the representation, if any, ceased at the moment Mr. Daybell retained Mr. John Pryor. The judge held a hearing on that issue and inquired of Lori whether she had reviewed and signed the written waiver, and she waived any conflict again of the record. Okay, so this name's in the state versus Lori, and it gives the case number. Okay. She indicated that she had ID. So let's talk about the case number up there, as did Chad at a later hearing. The judge concluded that while Means had represented both Chad and Lori before Chad was charged, creating a conflict of interest, both Lori and Chad had knowingly and voluntarily waived that conflict. Number two. Some 10 months later, on May 25th, 2021, the state charged Lori and Chad with murder, conspiracy to commit murder, and theft. Although the state charged both defendants in a single indictment, the district court assigned two case numbers, the case number for her and then Chad Daybell and his case number, for Lori Daybell, and then the other case number for Lori. This decision would have lasting implications moving forward. Number three. Before Lori was arraigned on the new charges, the district court found her mentally unfit to proceed, and it suspended her case. It remanded Lori to the custody of the Department of Health and Welfare for competency restoration, where she would remain undergoing treatment for the next 10 months. The court ordered that all proceedings in her case were to cease in her case except matters related to the competency issue. Yeah, that makes sense. Okay, roughly contemporaneously, Mark Means filed a notice of appearance as Lori's counsel in the murder prosecution. He now represented her in all three cases against her. Given that the death penalty was an option, the court appointed a second counsel for Lori, public defender Jim Archibald. Okay. While Lori's case was stayed, the state reviewed its attempt to disqualify Means based on his alleged brief simultaneously representation of Lori and Chad before Chad had been charged over a year earlier. The state filed this motion under both Chad and Lori's case numbers. Perhaps in response to the state's filing of the motion in both cases, the district court entered an order reiterating that each defendant had a unique case and a unique case number. The court confirmed that the cases are two separate cases, regardless of the single indictment, and that they will later only be joined for a single trial. The court ordered the parties to file all subsequent pleadings in each other's case, captioning only the individual defendant's respective case number and name. In the wake of that order, the court set a hearing on the state's motion to disqualify Means, but because it had stayed Lori's case, it set the hearing only for Chad's case. Mark Means filed a motion for intervention so that he could be heard on the issue of his own disqualifications. In his motion, he argued that he needed to present the facts and events necessary to resolve this disqualification issue, which squarely impacted his client's interest. He also noted that Lori has a right to choose her counsel of record, and the prosecution has taken a personal interest in obstructing her constitutional rights. Mark Means and Jim Archibald were present at the hearing, as well as the prosecutors and John Pryor for Chad Daybell. Okay. Chad did not initially attend the hearing because, as Pryor indicated, I see no basis for the court to go forward on this conflict in this case. According to Pryor, this motion was more properly brought in the Vallow case, meaning, Lori's. Hey there, proud grandpa too. So nice to see you. I'm so glad you came in today. Thank you. I hope you enjoy listening to me read. I really enjoy listening. I really enjoy reading to people. It's kind of fun for me, but anyway. So we're just talking about the brief that Lori Vallow filed in her death cases in Idaho. This is what I'm reading. Okay, so it was more properly brought in the Vallow case. Pryor repeated the sentiment multiple times throughout the hearing. If the state wants to pursue this motion, they can pursue it in the Vallow case. He goes, this is not part of this case, and it doesn't belong as part of this case. Acknowledging Pryor's concern, the district court noted that it probably is worth sorting out the issues at this point, of which the case we are hearing this motion in. Okay, and then it gives in number 9 and then 7 to 10. This is just numbers, which is part of it. But it then quickly moved on to Means' motion to intervene in Chad's case. Means argued that the state was circumventing the stay in Lori's case by arguing the motion to disqualify him in Chad's case. He claimed that he claimed that he shouldn't have filed a motion for intervention because the motion is pending for both of the cases, but he needed to this is really weird, but that he needed to be able to express our objection to ongoing forward based on the stay that is happening, as well as the other things that have filtered through in the discovery that the court should consider a motion such as this. While the state agreed with Means that this was really a single case against both defendants, and it disagreed with court's order splitting them, it still objected to Means' request to be heard on the disqualifications issues in Chad's case. Oh boy. Construing Means' motion strictly as one seeking formal intervention as a party, the district court denied the motion. Okay. It found that there was no authority allowing one defendant to enter as a party in another defendant's case, overlooking perhaps that it had artificially split the case to begin with, while the court allowed Means and Archibald to observe the hearing on the state's motion for disqualification. They were not permitted to participate. The state entered the direction of the hearing, which occurred on August the 30th and was continued to September the 8th, to focus on Chad's rights to conflict-free counsel rather than Lori's rights to counsel of her choice. At the hearing, the court admitted that the state Exhibit 4, partial audio recording of the April 28th jail call between Lori and Chad, in which Chad indicated to some degree that Mark Means was also his counsel at that time, that he was eventually going to go with the other guy. Eventually, the court came around to the state's view, noting that it needed to explore the nature of any potential conflict with Chad personally. Pryor again suggested that if the court wants to go on way of inquiry, that the inquiry should probably take place in the Vallow case and not the Daybell case. This gets confusing because they're both Daybells. The court took the matter under advisement. Within weeks, the court had held an ex parte hearing where only Chad and John Pryor were present. There, Chad clearly expressed the view that he did not consider Mark Means to have been his counsel at any point. At that time, Means had made his public statement about representing both Chad. Okay, guys, hang on. I'm getting a delivery at the door, and so every time we have these big metal gates on our front door, and every time they open this gate, it makes this, oh, thank you, proud grandpa, too. I appreciate you telling me you love my channel. I appreciate that. So every time somebody opens this big gate, it makes this loud noise. So the dog starts this barking thing, and I can't make him stop it. I've tried everything. But, he is a dog, so we got to let him bark. He's just doing his little job. So anyway, I think he's kind of quit. Let me see. We'll just talk for a minute so he doesn't interrupt my reading. Oh, Lord. Is it hot where y'all are today? I mean, I'm in Texas, and it's really muggy outside. It's really humid outside. But I thought it was going to rain, but it's just not. It's like it's just hanging over us. But then I read we were in a heat dome, and that's why we're having this kind of clouds. So anyway, I think he's kind of stopped. All right, we'll go back to our reading. So they had the ex parte. At that time, Means had made his public statements about representing both Chad and Lori. Chad had hired Pryor, but he did not necessarily want it to be known publicly that he had hired a criminal attorney. I guess he didn't want that to be known. You know why? Because he knew he did something wrong. Chad informed the court that he did not provide Means with any confidential information, that he was worried about being exposed. To the extent that there was any potential for a conflict, he consented to Means continuing to represent Lori. The court again took the matter under advisement. While the motion for Means' disqualification was pending, an issue bubbled up regarding Lori's communication with an attorney for the Church of Jesus Christ of Latter-day Saints. Means learned that a clinician at the state hospital had allegedly urged Lori to call the church to inquire about the possibility of obtaining legal counsel paid by the church to take the place of her appointed public defender, co-counsel Jim Archibald. Based on that, Means filed a motion alleging certain violations by the state, contending that Lori had spoken freely with an attorney for the church, who had indicated he might help her find additional counsel, only to turn around and give the information to the prosecuting attorney. Means issued the subpoena to various entities to get to the bottom of the contact between the church and the prosecutor. I didn't know about this. This is the first I've heard about that. And I thought I watched everything in this trial. The state responded by denying improprieties and claiming that the prosecutor had a very short conversation, about 1 minute, with an attorney at the law firm representing the church before notifying co-counsel Archibald of that contact. Well, I mean, I'm never going to side with her, but I will say this. Whoever she had contacted should have never contacted the prosecutor. That absolutely was wrong. But the state, the church is never going to represent, or they're never going to provide an attorney for somebody who's being accused, allegedly, of taking the lives of their children. That goes against everything the church teaches. So that's not going to happen anyway. Means' allegations and legal machinations clearly touch a nerve with the state, which again urged the court its responsive filing that Means had an unwaivable and unethical conflict of interest due to his past dual representation. The state further argued that Mr. Means' continued involvement in this case is inappropriate and creates issues for the appeal. Within a month of the dust-up, the court granted the state's motion and disqualified Mark Means as Lori Daybell's counsel. It concluded that Means had represented Chad at least for some period of time, that the representation created a conflict of interest, and that the court would not honor a waiver because of the severity of the case. Lori Daybell was still in the state hospital. She was not permitted to choose her own attorney. Well, I mean, she really wasn't mentally fit to choose her own attorney, if you think about it. She was proved incompetent, so how could she competently pick an attorney? She can't. Okay. B. Mrs. Daybell's competency was restored by April 11, 2022, and the district court lifted the stay on her case. She was arraigned on the charges, and the state filed a notice that it intended to seek the death penalty. The district court appointed attorney John Thomas as co-counsel to Jim Archibald. At her arraignment, Mrs. Daybell demanded her right to speedy trial, a position that she reiterated repeatedly throughout the case. The case was set for trial the following October. Almost immediately, the state filed a motion, ding, 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 to continue the trial. Over Mrs. Daybell's objection, the district court granted the state's request and reset the jury trial to begin in January of 2023. Now, listen to this, guys. Now, okay, so she's told she's competent, right? But if you listen to the interview that she had with Nate Eaton the other night, that I kind of showed a little bit of yesterday, I just don't believe she's competent. I still do not believe that this woman is competent, not at all. She just keeps on going with this nonsense. I mean, our God is never going to tell you to take the lives of your children, that you need to give everything up, and that it's okay. Because in the name of, in his name, okay. In September, Mrs. Daybell's counsel received information from a mental health professional that they believed required a reinvestigation of her competency. They filed a motion to continue the trial and told the deadlines for pretrial filings. At the hearings on the motion, Mrs. Daybell expressly disagreed with the findings of the mental health evaluator and objected to a continuance. She told the court that she believed that the assessment was an attempt to prolong the case and that I am unwilling to give up my rights to waive my right to a speedy trial. Oh, there you go. Of course you did. Nonetheless, the court granted a continuance and held a competency hearing in November, after which again found Mrs. Daybell competent to proceed. It reset the trial for April 3rd, 2023, which is about 90 days later than the January setting. Mrs. Daybell moved to dismiss the case, claiming that her speedy trial rights were violated. The court denied that motion. And then we go to C. The district court grants the state's permission in this case. Some 8 weeks before the trial, the state filed a motion to introduce evidence under 404B of the Idaho Rules of Evidence. In the motion, it listed general nature of the evidence, and it sought to introduce, which included some 27 categories of evidence related to the Charles Vallow's death, Lori's previous husband's death, and other evidence. Mrs. Daybell counsel objected to the state's motion, filed to give them reasonable notice, saying, you didn't give us enough time to do this. They argued that the state intended to introduce an erroneous amount of evidence from Arizona at the last minute, essentially another entire case. The state has been hiding the ball on this issue for at least 1 year, 8 months, and 16 days between the grand jury indictment and the proposed date of this hearing. Yeah. So the court expresses, hey, true crime. Hey, I'm sorry, Marley. Let me see. We're in a monsoon season. We're waiting for rain. Oh, really? It's cloudy. Oh, wow. Well, I think y'all are in part of the heat dome that we are too. Texas. I think that the few of the states down here in the South are actually. I know you can't see my hand. Are actually in that same heat dome. So I hope y'all don't get flooded. I really do. The court expressed some agreement that the state's motion was overbroad and vague, which prompted the state to file an amended motion to introduce the 404B evidence. In the amended motion, it indicated that it intended to introduce evidence primarily related to the circumstances surrounding the death of Charles Vallow and the attempted shooting of Brandon Boudreaux, Melanie Pulaski's ex-husband. The defense again objected, noting that the enormity of the evidence and the burden it would put on the defense to investigate all those matters before the trial was set to begin in a few short weeks. It was just too burdensome. The court granted the state's amended motion with a few minor exceptions. It concluded that the evidence related to the shooting of Charles Vallow, the investigation into the shooting and related matters was permissible to show the defendant's plan, preparation, and knowledge and an identity. It likewise allowed evidence of the attempted shooting of Brandon Boudreaux also to show preparation, plan, knowledge, and or identity. It concluded that the probative value of the evidence was not outweighed by the danger of an unfair prejudice. Wow. It's so strange because, they did these cases first and did those cases second. So you got to kind of wonder, how would they bring those in, because she wasn't actually charged with it yet. Remember, she had not been charged with that yet. Anyway, so less than a month before this trial, the state dumped an additional discovery on the defense, well past the discovery deadline. This was the pattern throughout the case. The defense filed a motion to strike the death penalty as a sanction for the state's discovery violations. The court granted that motion. The court concludes here, you're in Utah and it's super nice. Oh man, 89 degrees. Oh Lord, that's so nice. I bet it's cool there at nighttime too. That would be, oh Lord. I bet it's so nice. I wish we could, the best weather I've ever been in was in Hawaii. It was just like the same temperature all the time. But it's so expensive to live there, who can? Anyway, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at a trial, and that the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken. So that's how she got away with not being given the death penalty. It's been great. It's usually super. Really? I would have thought that in Utah, because it's so far up north, that it would not be hot, that it would kind of stay cooler. But I guess, I just really never know that. I'm sure y'all get snow on the mountains and all that, right? I always wanted to go to Utah. It just seems like it's so pretty. I also want to go to North Carolina. I love to travel, but we can't just travel all the time. I wish we could. All right. Because Chad waived his right to a speedy trial, the court severed the cases and kept Lori's case on track for trial to begin on April the 3rd. The death penalty remained an option in Chad's case. Uh-oh. Oh, it's 100 degrees there yesterday? Wow. So I guess you're glad you got that cloud today then, right? I would be too. I don't know how. Let me see something. I want to see how hot it is here. Let me look at my phone. Take a break from reading for a second. I find all this super interesting to know everything that's going on in the background, because a lot of it we never saw. We just got, it's 89 here. So our high today is 89. Oh no, tomorrow we're going to get rain. Okay. All right. That's okay. I would love some rain because we need the rain. It's so dry here. All right. 89. Nice. Nice. Yes. Okay. The trial summarized. The trial proceeded as scheduled, lasting about 6 weeks with 60 witnesses, in addition to the basic historical facts recited in this brief. The state's case at trial relied on other circumstantial evidence, including cell phone geolocation, data placing Alex Koch at the burial sites, evidence of text messages and emails exchanged among the alleged co-conspirators, and witnesses' testimony about Lori and Chad's religious beliefs and statements. The defense countered that there was no physical evidence tying Lori to any of the deaths, that the alleged conspiracy to murder anyone was entirely circumstantial and speculative, and that the state was using prior bad acts to shore up its case and imply guilt. The jury ultimately found Lori guilty on all counts. The district court sentenced her to 3 consecutive terms of life in prison with no possibility of parole for the first-degree murder, 2 concurrent sentences of life without parole for the conspiracy to commit murder, and concurrent sentences of 5 to 10 years in prison for the grand theft. And the grand theft was the insurance money, or the Social Security money. That's what the theft was. Okay, so the issues presented on appeal. So this is what they're really getting down to, why they're going to appeal this. Lori Daybell was deprived of her Sixth Amendment right to counsel of her choice when the district court disqualified her retained attorney. Number 2, Ms. Daybell was deprived of her Sixth Amendment right to the assistance of counsel during pretrial hearings on state's motion to disqualify her counsel after the district court denied her attorney's request to participate in those hearings. Number 3, Ms. Daybell was deprived of her right to due process under the 14th Amendment when the district court held pretrial hearings that affected her substantial rights in her absence and while she was incompetent. Number 4, the district court erred in allowing the state to introduce evidence of uncharged bad acts from Arizona into the Idaho criminal trial under Rule 404B of the Idaho Rules of Evidence. Now, I kind of just talked about that because she had not been charged yet. So that is a true statement right there. The district court erred in denying Mrs. Daybell's motion to dismiss based on a violation of her statutory and constitutional rights to a speedy trial. I know she's out of her mind, but I mean, that kind of did happen because she had not been charged yet. But anyway, I don't think this appeal is not going to do her any good. It's not, and nothing. This is not going to work. So here's their argument. Lori Daybell was deprived of her Sixth Amendment right to counsel of her choice when the district court disqualified her retained attorney. And here's the introduction. A criminal defendant has fundamental rights under the Sixth Amendment to hire counsel of her own choosing, free from interference from either the state or the trial court. Mrs. Daybell retained attorney Mark Means to represent her against the charges. The state moved to dismiss Means based on a purported conflict of interest. The district court channeled the motion into Chad Daybell's case and did not allow Means to participate in the hearings on this issue, conducted an ex parte meeting with Chad before granting the state's motion. This all happened in Lori Daybell's absence while she remained incompetent. I'm so glad, proud grandma, that you followed this too, because there's a lot to this. There is a lot. Ultimately, there was no actual conflict of interest. Any potential conflict had been waived by both parties, and the district court erroneously focused on Chad's rights to the exclusion of Lori's rights to counsel in her own choice. The district court abused its discretion in granting the state's motion, and the court should reverse. Ooh, I hope they don't get it on that. I hope so. All right. Standard of review. A district court retains discretion to grant or deny the prosecution's motion to disqualify the defendant's retained counsel based on an alleged conflict of interest. And then it states the cases there, which I'm not going to read all that. Under an abuse of discretion standard, the court must determine whether the trial court, 1, correctly perceived the issue as one of discretion, or number 2, acted within the boundaries of such discretions, or number 3, acted consistently with any legal standards applicable to the specific choices before it, and number 4, reached its decision by an exercise of reason. All right. Standard of law. The Sixth Amendment provides in all criminal prosecution, the accused shall enjoy the right to have the assistance of counsel for their defense. The U.S. Constitution, Amendment number 6, the United States Supreme Court has long held that the Sixth Amendment guarantees a defendant the right to hire her own attorney if she can afford to do so. Okay, could she afford to do so? Because guess what? Guess whose money they were using? They were going to use Chad Daybell's money after they had, taken the insurance money that he got from the death of his wife to represent her. Yeah, right. She could not really afford because it was blood money. He was going to use blood money. All right. Boy, that's so bad. The Supreme Court has found that the right to counsel of choice to be grounded in those close working relationships between lawyers and client the need for confidence, and the critical importance of trust. Okay, the right to select counsel of one's choice is thus the root meaning of the Sixth Amendment. Okay, the right also extends to representation by attorney who, as here is, willing to represent the defendant even though she is without funds. So no matter whether she had the money or not, he had said, oh, he would represent her. There is a strong presumption in favor of counsel of choice. Okay, as with all constitutional rights, however, this right is not absolute, and an advocate who is not a member of the bar may not represent clients in court. Nor is an indigent defendant entitled to choose his or her appointed counsel or to insist on a private attorney who does not wish to represent the defendant. And finally, courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that the legal proceedings appear fair to all who observe them. In Wheat, that meant that the district court had acted within discretion in refusing the defendant's waiver of conflict-free counsel when the attorney he wanted to hire also represented other defendants concurrently in the same drug conspiracy case. So they're just talking about, some case that they cited for the reason why that they think that they needed to, that she was denied her rights. The Supreme Court held the presumption in favor of the defendant's counsel to choice can be overcome by showing a serious potential conflict. Yet 30 years after Wheat versus the Supreme Court has recently reaffirmed the centrality of the right to choose one's own attorney under the Sixth Amendment, we nonetheless emphasize that the constitutional right at issue here is fundamental. Okay. So while a trial court retains power to disqualify the defendant's counsel of choice, disqualification of counsel should be a measure of last resort. Where the right to choice of counsel is, okay, my dog's gonna bark just a minute. Shh, baby. He's so funny. This is my little Frenchie, it's little Jack, 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 no. Anyway, where the right of counsel is wrongly denied by a court, it is unnecessary to conduct an ineffectiveness or prejudice inquiry to establish a Sixth Amendment violation. Okay. Deprivation of the right is complex when the defendant is erroneously prevented from being represented by the lawyer he wants, regardless of the quality of the representation he received. Boy, this is a lot, isn't it? Here's the discussion. The district court's handling of this issue was seriously flawed from the beginning due to the desire to split the cases into two for all pretrial purposes. It routed hearings on the state's motion to disqualify Lori Daybell's retained counsel to Chad Daybell's case number. As Chad's trial counsel, John Pryor, noted and repeatedly that this was the matter was best addressed in Lori's case after she regained her competency. While Chad had an interest in the matter, the state and the district court breezed by Lori's fundamental right to choose her attorney. Worse, the district court refused to allow Means to participate in these hearings, even though the precise issue was whether he had a conflict of interest and even though his client's rights were at stake. Meanwhile, oh boy, Lori sat in the state hospital, incompetent to proceed and absent. The procedural errors by themselves sufficient to warrant reversal, as Ms. Daybell argues in issues 2 and 3. Here, though, she challenges the district court's ruling squarely on its merits. The right to counsel of choice is fundamental. Deprivation of that right is a structural error, not subject to harmless error analysis. A court that is assessing whether to disqualify a defendant chosen counsel must take considerable care in balancing the rights and interests at stake. All right. A court that is, okay, we've done that to stay considerable balance. Okay, all right. Ooh, I lost my place. Okay. The district court abused its discretion because it focused on Chad Daybell's rights to conflict-free counsel and the exclusion of Lori Daybell's fundamental rights to counsel of choice. It did not act consistently with the legal standards applicable to the specific choices before it. The district court's myopic approach is readily apparent in how it conducted hearings on this issue. Initially, the court appears to have been sensitive to the needs to halt all proceedings in Ms. Daybell's case while she was incompetent. Its orders indicated that all matters would cease except those related to the competency. The court's unusual choice to split the cases also suggested that it was concerned about the need to cease litigation in Lori's case while litigation would move forward in Chad's case. At the beginning of the hearing on the motion to disqualify, moreover, it hinted at an awareness of the problems inherent in litigating the matter in a co-defendant's case that affected co-defendant A's case that affected co-defendant B. Substantial rights, while co-defendant B's case was stayed for incompetence. Preliminary, it noted that it's probably worth sorting out the issues at this point, of which a case we are hearing this motion, and noting that, and it cites this other case, which I'll refer to as Vallow case. It's concurrently stayed. All right. It is later queried, oh boy. So the issue is now, are we properly to hear motions objecting to Mark Means representing Lori Vallow Daybell in this case, or does the court have the ability to consider that in a separate defendant's case? Despite those early glimmers of the recognition that had a problem on its hands, it eventually decided that the state's motion without input from Lori or her counsel. Ultimately, the conduct of the court was persuaded by the state that it must conduct an inquiry into the conflict with Chad. It continued down the primrose path by holding an ex parte meeting with Chad to inquire about the alleged conflict. The flawed process led to the flawed decision. In the memorandum decision, the court acknowledged that the defendant has a Sixth Amendment right to counsel of choosing, but it concluded that there was an actual conflict of interest that could not be waived due to the severity of the charges in this case. All right. It referred to primarily the magistrate judge's previous ruling finding an actual conflict of which it took judicial notice. The precise nature of this supposed conflict was never explained, however, presumably because one did not exist. Mark Means did not. He's going to hang on. I'm sorry. Trying to get you to stop that. All right. I'm just going to keep reading. I'm so sorry. The precise nature because it did not exist. Mark Means did not concurrently represent Chad Daybell, so the duty of loyalty would arise only in the context of duty owed to a former client. It is true that over a year and a half before the court's ruling disqualifying him in this case, Means portrayed himself as representing Chad before Chad had been charged. At that time, he also represented Lori, but to the extent that he truly represented Chad in some capacity as his attorney, it was for a matter of weeks. As bar counsel apparently told Means, this was a cup of coffee that ended at that moment that John Pryor was hired. Even assuming that Means represented Chad at one time, the heart of any conflict of interest is whether the attorney's representation would be materially limited by conflicting duties of loyalty to concurrent clients or former clients. As applied here, an attorney in Means' position could have divided the loyalties if he had learned something from Chad that would help his client Lori at trial. But he also still owed a duty of loyalty to his former client Chad. What is woefully absent in this record, though, are in any facts of which the court could rely to find that Means had such information or had some other material limitations moving him forward. Wow, that's a mouthful. And the best evidence of that issue came directly from Chad Daybell himself as he squarely, contrary to the district court's ruling. During the court's ex parte colloquy with him, Chad unequivocally asserted that he did not consider Means to be his attorney. Question: did you ever understand that he was representing you? A, never. Okay. More to the point, Means and Chad never discussed any confidential information. The court was giving any facts, just yes or no. At any point, did you discuss, this is the questions they asked him, did you discuss with Mr. Means any of the factual details of Lori's case or the circumstances surrounding her case? The defendant says no. Did you ever discuss with Mr. Means any facts from your own personal knowledge about anything you've been charged with or that Lori's been charged with in any of the cases? The defendant says, I would only say it was more court appearances. It is all he ever discussed with me is regarding Lori's court appearances. Okay, could I such as the dates that she would appear in court. Okay, so he mentioned to you when the court would be. Yes. Okay. Pryor reiterated to the court, as he had repeatedly, that I do not see a conflict here. I don't see a problem. I don't perceive any issues with this. And frankly, Ms. Vallow has no information about Mr. Daybell that could cause him any concern anyway. Chad has unequivocally told the court that he had no problem with Means continuing to represent Lori. While the district court noted in his memorandum of decision and order disqualifying Means that the conducted ex parte inquiry with Chad, there's the numbers, the facts that the court learned from the inquiry did not make it into the ruling. Whatever else he might have said about whether Means represented Chad in some capacity, what Chad told the district court undermines the court's conclusion of an actual conflict of interest. There is simply no substantial and competent evidence supporting an actual conflict of interest in this case. Still, it is true that the Supreme Court noted in the Wheat versus serious potential for conflict might be sufficient to warrant overcoming a defendant's choice of counsel and waive any conflicts. This court should now view Wheat through a prism of more recent cases on defendants' right to counsel of choice, such as Gonzalez versus Lopez or Lopez, which reaffirms the certainty of the right to the Sixth Amendment. Regardless, there was no serious potential conflict either. In Wheat, the defendant was affirmatively seeking the substitution of an attorney the day before the jury trial, while the attorney was actively and contemporaneously representing two of the co-defendants in a complex drug trafficking conspiracy, which is very different than, an unaliving case. The attorney's involvement with the other clients was deep, long-lasting, and ongoing. The government intended to call one of them who had pled guilty at trial, creating a serious risk that the chosen counsel would need to cross-examine his own client. On those facts, the Supreme Court held that the trial court was within its discretion to find that a serious potential for conflict would arise during the criminal trial. Here, in contrast, it means represented Chad, a disputed fact. It was superficial and brief. Unlike Wheat, this limited representation occurred before Chad was charged criminally, ending well over a year before the issue was raised at the present case and long before the trial was even on the horizon. And the only evidence that the court had before it about Chad had imparted in any confidential information to Means was that he had not provided any such information. Chad also retained his own criminal defense attorney, Mr. Pryor, who had represented him for a year and a half. And the entire fact-finding endeavor was tainted from its inception because of the serious procedural flaws in the inquiry. Lori was incompetent, unrepresented on the issue, so her wishes were not considered. None of that was true in Wheat. That's why they're saying you can't use that one. Any risk that was mitigated even more because both Chad and Lori clearly expressly waived any potential conflict in writing. The reaffirmation of their waivers at the hearing and the destruction of the evidence case in front of the magistrate judge. Wow. Chad reaffirmed it yet again to the district court in the presence of the case at the ex parte hearing. Let's see. How long have we been on here? An hour. Okay. I only like to go like maybe an hour and a half or 2 hours. So I'm going to read a little bit more. We'll just see how far we can get. Because we're on page 42 out of 71. Just to let you know how long this really is. I want to finish this because I really want to get onto my Justin Banta case because that case, so fascinating. Anyway, in short, the potential for conflict of interest in this case was speculative, attenuated, and nearly non-existent, while the potential for a conflict in Wheat was immediate, probable, and serious. When competing constitutional rights are at stake, a court has a duty to accurately weigh the risk and balance the importance of the rights. Here in the district court abused its discretion by using a miscalibrated scale with a thumb on one side because it did not receive any input from Lori or her counsel. But more than that, the evidence of the potential conflict fell far short of what is required to overcome a defendant's constitutional right to counsel of choice. This case instead has hallmarks of what the court in Wheat acknowledged was a possibility. The prosecution may seek to manufacture a conflict to prevent the defendant from the services of any attorney that the prosecution dislikes. Oh boy, that's really harsh, and I can't believe they're saying that. I mean, how can you accuse the courts of that? Wow. It is true that means engaged in unorthodox practices, perhaps even practices that were not necessarily helpful to his client. But some of those practices, including accusing the state of impropriety through contact with the Church of Jesus Christ and the Latter-day Saints, clearly ruffled the state. The state repeatedly and vigorously tried to get Means dumped from the case. In an adversarial system, the court should look upon such efforts with a jaundiced eye. A jaundiced eye, that's kind of funny. At the core of the Sixth Amendment is the right for the defendant, if she can afford private counsel or counsel is willing to represent her, to decide who she trusts and who she believes will represent her interest in court, regardless of whether the attorney is viewed by others as the best one for the job. As the Supreme Court has recognized, this right is grounded in the close working relationship between lawyer and client, the need for confidence, and the critical importance of trust. Lewis versus, okay, there's that page. The right to protect the defendant's individual liberties and reflects dignitary interest. It is not the right that intended to ensure the best representation possible. Is it not the right that it's intended to ensure the best representation possible? Okay. In the way, it is similar to the right of the self-representation, which almost never enhances the quality of representation at a trial. Yeah, we know that, don't we, Lori? Look what happened to you. Okay. The language and the spirit of the Sixth Amendment contemplate counsel, like the other defense tools guaranteed by the amendment, shall be an aid to a willing defendant, not an organ of the state interposed between an unwilling defendant and his right to defend himself personally, regardless of what Means idiosyncrasies were. They were the idiosyncrasies that Mrs. Daybell chose. It was her counsel of choice, and the state had a burden to present extremely persuasive information in a reliable and adversarial proceeding, a serious potential conflict of interest before the choice should have been removed from her. It did not, and the district court abused its discretion in granting the state's motion. For all these reasons, the court should conclude that the district court violated Mrs. Daybell's Sixth Amendment right to counsel of her choice when it granted the state's motion for disqualification. All right. Mrs. Daybell was deprived of her Sixth Amendment right to the assistance of counsel during a pretrial hearing on the state's motion to disqualify her counsel after district court denied her attorney's request to participate in those hearings. Oh boy, I think this is going to be a lot of the same thing. Let me see. The court disagrees with Mrs. Daybell on the merits of the district court's disqualification ruling of any reason. It should still conclude that the procedure by which the district court heard and decided the motion violated Mrs. Daybell's constitutional rights. Here she asserts that the district court's ruling prohibiting her counsel from representing her interest at the hearings at the state's motion violated her Sixth Amendment right to the assistance of counsel at all critical stages of this prosecution. As far as the first issue, this was structural error that required reversal. Wow. Hey, Michelle L. Hey, good to see you. I know it's been forever. So glad to see you. I am just I'm just reading the brief that was filed by Lori Vallow's attorneys, her appeal attorneys, on her cases in Idaho. So I'm just going to read this out loud. Yeah, I know it's been forever. I really was not. For a few weeks there, I didn't do very well. I didn't really go live and stuff. I was just kind of not feeling good. And then we went on this vacation. So finally, everything's leveled back out. So I really want to get busy again. I'm so glad you came in, though. I like to go during the daytime, and I'll tell you why. At night, all these other people are going live, and, I'm interested in the cases that they're talking about. And so we can't all be live at the same time. So what I've decided to do is I'll just do mine during the day so that I can listen and participate with my friends at nighttime. And, when they're live, and it just works out that way. And so I always tell everybody, just if you need to listen on replay, who cares? Just go and enjoy it. Anyway, I'm so glad to see you, Michelle. So I'm going to try to see how many pages I can get through on this one. because it's 71 pages, but we're on page 45. Okay, so hold on. I know it's a lot. Mrs. Daybell acknowledges that her counsel did not argue specifically that if the district court denied his motion to intervene, then his client would be deprived of her Sixth Amendment right to the assistance of counsel at a critical stage in her prosecution. Alleged constitutional errors. You too? Okay. Alleged constitutional errors during the trial that are not followed by a contemporaneous objection must be reviewed under the fundamental errors doctrine. Okay, and it names the case that where it talks about that. Okay. The fundamental error doctrine involves a three-pronged inquiry to determine whether the alleged error, number one, violates one or more of the defendant's unwaived constitutional rights, or number two, plainly exists, or number three, was not harmless. And it gives the cases. The defendant bears the burden of persuasion on each of these prongs. Well, she was not there, was she? Oh, wow. Hello. Yeah, hey, Sprinkle Donut. So glad. I know. Y'all talk amongst yourself while I read. Anyway. The second prong requires that the error to be clear and obvious from the record, including information as to whether the failure to object was tactical decisions, and it names this, the case that it's citing. If the record does not contain evidence regarding whether trial counsel's decision was strategic, the claim is factual in nature and thus more appropriately addressed via a petition for post-conviction relief. Okay, and that's what they're doing, post-conviction relief. Once the state has initiated the adversary judicial process against a defendant, the Sixth Amendment guarantees a defendant the right to have counsel present at all critical stages of the subsequent criminal prosecutions. The adversary process begins with an indictment or other formal charge. Okay, let's see. The Sixth Amendment right to counsel is triggered by the filing of a criminal complaint or an indictment. Critical stages of criminal prosecution are broader than just the trial itself, as the accused is guaranteed that he need not stand alone against the state at any stage of the prosecution, formal or informal, in court or out, where counsel's absence might derogate from the accused's rights, to a fair trial. Let me take a drink. My mouth is so dry. Nice cocoa. Okay. All right, go ahead. So a critical stage, therefore, is any stage of criminal proceeding where substantial rights of criminal accused may be affected. Okay. There's lots of sightings in here, so all right. Critical stages include, for example, post-indictment police lineups, arraignments, preliminary hearings, and sentencings. And the United States, and then it names adding the sentencing, and it names another case that it's citing, and it goes on down and names another one. Prejudice is presumed when a criminal defendant has been completely denied the right to counsel for critical stages because it is an error that contaminates the fairness of the entire proceeding and is not subject to the harmless errors and analysis. And it cites another one. Okay, so here we go. Holding that the absence of counsel at a victim's allocation during the sentencing phase was a structural error requiring to be. Okay, that's talking about the case they cited. So here's the discussion. All right. The state initiated adversary judicial proceedings against Lori Daybell when it indicted her on May 25, 2021. Mark Means formally entered his appearance as her counsel soon thereafter. Her Sixth Amendment right to the assistance of counsel attached to all subsequent critical stages of the criminal prosecution. The hearing on the state's motion to disqualify Mrs. Daybell's counsel was a critical stage. It is irrelevant that those hearings were not held under her case number. The Supreme Court has held that a critical stage is any proceeding, formal or informal, in court or out, whether counsel's absence might derogate from the accused rights to a fair trial. Let me scroll this up some. Oh boy. Okay, then it cites another case. The court, it says, in Wade, for instance, the court held the defendant was entitled to counsel's presence at the post-indictment police lineup. What matters is whether the proceeding is one where substantial rights of a criminal accused may be affected. And it cites another one. A hearing in which the court is taking evidence, hearing arguments, and weighing whether to dismiss a defendant's attorney is surely one in which the substantial rights of a criminal accused may be affected. Yeah, okay. And it cites another one. Mrs. Daybell had a Sixth Amendment right to counsel to represent her interest in that hearing. She did not waive that right, and she could not since she was incompetent. So she meets the first element of the fundamental error test. The second part of the fundamental error review looks to whether the error is clear and obvious, meaning that the record must contain evidence that the trial counsel's failure to object was a tactical or strategic decision. Mrs. Daybell also meets this element. In fact, her counsel did object below and asked to be heard on the matter of the hearing. He claimed the state had taken a personal interest in his dismissal and was trying to circumvent his client's right to counsel of her choosing. He appeared at the hearing and argued that the court should not be proceeding with an issue in Chad's case. He perhaps mistakenly framed his request as one seeking to intervene, which the court construed quite literally as seeking an intervention as a party rather than simply a request to represent his client. There can be no plausible tactical reason to argue ferociously, to be present and heard on the issue, and yet intentionally chose not to cite the client's Sixth Amendment right to counsel. For support that Mrs. Daybell can satisfy the second prong of the Perry fundamental error test, this court can also look to State versus self-defense case. His attorney objected to the trial court giving any initial aggressor instructions, in which the court overruled, but counsel did not object to the final instruction as worded. On appeal, the Idaho Supreme Court held that the issue was not preserved, but that Bodenbach easily satisfied the second prong of Perry versus, as the error is clear, okay, on the Perry citing, right, that the error is clear from the record and was not tactical decision because defense counsel attempted to prevent the jury from being instructed regarding an initial aggressor, okay, which I think they mean is like it was kind of a self-defense thing, and so this initial aggressor might have been like there was somebody else involved in this. It wasn't, anyway, that's what I think that means, but I'm not going to go look up this case, so we'll just keep going. Like in Bodenbach, where a trial counsel, okay, let's see, now let's go here. Here we go. As for the third element, normally the appellant would bear the burden to show that the error affected the defendant's substantial rights, meaning, in most instances, that it must have affected the outcome of the trial proceedings. And then it states the Miller versus whatever. This case, however, is one of the minority instances that is so because the complete denial of counsel at critical stages is not subject to the harmless error analysis. The absence of counsel makes the proceedings itself unreliable, and there is no way for a defendant to prove how counsel's presence might have changed the outcome. Structural errors defy analysis by harmless error standards because they affect the framework within the trial proceeds and are not simply an error in the trial process itself. Counsel was not absent for a mere blip in the proceedings or at some inconsensual point. There was a hearing that impacted Lori Daybell's fundamental right to choose who she wanted to represent her. The court held that the hearing took argument from the parties, excluding Mrs. Daybell's counsel, on August the 30th of 2021, which is continued to September the 8th, so that Chad Daybell could present, but not Lori Daybell. At the September 8th hearing, it admitted evidence. It then continued to hear this issue when it went fact-finding at an ex parte meeting between the court and Chad and John Pryor. All of these junctures, Mrs. Daybell's rights were unrepresented. It's not possible to reconstrue what the outcome might have been had counsel been permitted to actively represent Ms. Daybell at these critical points in her case. To be sure, he could have offered his version of the facts regarding the alleged simultaneously representation. This is a lot. He could have also argued to the court that Chad's comments at the ex parte hearing should have been given great weight. He could have impressed upon the court that the importance of Miss Daybell's right to counsel of choice, which seemed to get overlooked in the process. This results of the motion of disqualification cannot be said to be reliable, and important interests were unrepresented, and there is now no way to predict that the outcome of the trial had means remained on the case. It's like saying, okay, well, maybe she would have been found guilty. I don't think it makes a difference, but I'm not on the Supreme Court. The court should reverse Ms. Daybell's convictions and remand for a new trial due to the complete denial of her Sixth Amendment right of counsel at critical stages in her criminal prosecution. Number 3, Ms. Daybell was also deprived of her due process of right under the 14th Amendment to not be prosecuted while she was incompetent. Her related constitutional rights to be physically present at all critical stages when the district court held pretrial hearings in her absence on the state's motion to disqualify her counsel. Woo, boy. The issue is similar but independent of the last. Here, Ms. Daybell contends that the district court's decision to route the state's motion for disqualification to Chad Daybell's case, where it was actively litigated while she was incompetent, and her absence violated her 14th Amendment due process of law. Standards of review. As with the last issue, Ms. Daybell's counsel below did not cite the 14th Amendment as a basis for the court to withhold litigating the state's motion until a client was competent. This court's standard of review is again one of looking for fundamental errors. The court must review the record to determine whether the alleged error, number 1, violates one or more of the defendant's unwaived constitutional rights, or 2, plainly exists, or 3, was not harmless. Here's the legal standards. Right to not be prosecuted while incompetent. The United States Supreme Court repeatedly and consistently recognized that criminal trial of an incompetent defendant violates due process. Okay, there's the citing. The Constitution requires that a defendant be able to make rational decisions that are deemed essential to a fair trial, including the right to effective assistance of counsel, the rights to summon, to confront, and to cross-examine witnesses, and the right to testify on one's own behalf or to remain silent without penalty for doing so. Once the trial court has bona fide doubt about the defendant's competency to proceed, it must suspend the trial until it can resolve the competency issue. Okay. A defendant is guaranteed the right to present at any stage of the criminal proceedings that is critical to its outcome if the presence would contribute to the fairness of the proceedings. Let's see. Go here. At any stage of criminal proceedings where substantial rights of criminal accused may be affected. Okay. Although the constitutional right to the presence during the critical stage of the criminal proceedings is rooted to a large extent in the Confrontation Clause of the Sixth Amendment, the Supreme Court has recognized that the situations where the defendant is not actually confronting the witnesses or evidence against him, the right to presence is protected by due process clause. While the right to be present is an essential condition of due process, it is not absolute. In Snyder, the Supreme Court explained that although the defendant may have a right to be present on his own person whenever his presence has a relation reasonably substantial to the fullness of his opportunity to defend against the charge, the defendant has no right to be present when the presence would be useless or the benefit but a shadow. Okay, it was like, therefore, the presence of a defendant in a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to the extent only. Wow. The discussion. This is a lot to read, isn't it? Okay. Y'all doing okay over there? Yeah. Oh, wow. Yeah. Okay. For the same reasons that Ms. Daybell gave in issue 2, the hearings on the state's motion for disqualification of her counsel amounted to a critical stage of the prosecution against her. The resolution of the hearings affected her substantial right to counsel of her choice. Applying the first prong of the Perry fundamental error, Ms. Daybell did not waive her constitutional rights to the presence or agree that proceedings can occur during her incompetency. She had no choice in the matter. She was found to be incompetent by the court, and the court remanded her to the custody of the Department of Health and Welfare. She could not have knowingly or voluntarily waived the constitutional rights in any event. The error plainly exists on this record. There is no dispute that she was incompetent during the time frame. She was not physically present during the hearings on the disqualification of her counsel. As with the last issue, Means attempted to be heard at the hearing. In fact, he expressly noted that we need to express our objection to going forward based on the stay that is happening. Okay. While he may not have cited constitutional grounds, he raised the issue at the proceedings and in face of stay for incompetency. As in Bodenbach, this is evidence in the record that counsel did not make a tactical choice of foregoing citing constitutional basis for his objection. Mrs. Daybell contends, your phone keeps throwing, I'm sorry, I wish it wouldn't do that. Are you having problems with the internet? It's okay, Michelle, it's okay. Please just come back, Mrs. Daybell contends, as in issue 2, that placing a burden on her proved that the error must have affected the outcome of the trial proceedings. It is inappropriate given the right that was at stake. It is not possible to prove that she had been competent and had physically been present to be heard on this issue, that the outcome of the trial would have been different. This is unknowable. But had the district court delayed hearings this issue until she was competent and present, as it should, she would have been able to express why she wanted Means to continue as her counsel. In assessing the harm from the issues number 2 and 3, the court should keep in mind that Ms. Daybell's absence and the court's refusal to allow her counsel to participate in these hearings work together to deprive her of having a voice in critical issue of who would represent her in trial. Had one of these been different, then her interests might have been represented. They simply were not. She respectfully contends that this court should reverse and remand for a new trial. This is number 4 on this issue. The district court erred in allowing the state to introduce evidence of uncharged bad acts from Arizona into Idaho criminal trial under 404B. The evidence. Mrs. Daybell contends that she was tried as much for her character and conduct in Arizona as she was for the charged crimes. This court should reverse on any of the several grounds retained to the admission of wholesale, and talking about the RE 404B evidence. First, the state gave unreasonably late notices of its intent to introduce the evidence from Arizona in this case. Next, the evidence introduced was not relevant to prove plan, preparation, knowledge, or identity, and was instead largely propensity or bad character of evidence. Finally, even if there was some probative value from the Arizona evidence as to one or more of the 404B factors, the danger of unfair prejudice flowing from this evidence substantially outweighed its probative value, and the admission of the evidence led to confusion of the issues and was misleading to the jury. Wow. There's that 404B. Yes, she did talk about that a lot. And see, Michelle, you weren't in here, but I have all the 404B filings that the state did, and it included their little witness list and all that. But then when they decided not to use the 404B against her in their Arizona trial, the last trial, then I just never brought it out to you guys. But I mean, I will later. But yeah, it's all pretty interesting, really. So here we go. The standard of review. Okay. Questions of relevance are reviewed de novo, and citing some other cases over here. Once relevance has been established, this court reviews a trial court decision to admit evidence from abuse of discretion. Okay. Under an abuse discretion standard, the court examines whether, number 1, the trial court correctly perceived the issue as discretionary, and number 2, the trial court acted within the outer bounds of its discretion and with applicable legal standards, and number 3, the trial court reached its decision through an exercise of reason. Standard of law. It is well established the evidence of other crimes, wrongs, or acts is not admissible to prove criminal propensity. That is, evidence of the other crimes, wrongs, or acts cannot be introduced as evidence that a defendant who committed a prior bad act is more likely to have committed the current charged bad act. Such evidence may, however, be introduced if probative of another relevant matter, such as motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake, or lack of accident. 404B requires that the prosecution to serve reasonable notice of the general nature of any such evidence that the prosecutor intends to offer at trial, and do so reasonably in advance of trial or during trial if the court for good cause shows excuses, lack of pretrial notice. Wow. The Supreme Court has held that the compliance with the notice requirement of Rule 404B is mandatory and conditions precedent to admission of other acts evidence. That's a little bit hard to say, isn't it? Is mandatory and a condition precedent to admission of other acts of evidence. Okay. The rule is intended to encourage disclosure by the prosecution and discourage trial by ambush. Okay. Which you remember, Lori said, I'm just being ambushed. I'm just being ambushed into a trial. She said all that. Remember that? Okay. If the prosecution has given reasonable notice in advance of the trial, or the lack of pretrial notice is excused for good cause, Idaho courts follow a two-tier process to evaluate the admissibility of evidence offered under Rule 404B. The first tier has two steps. The trial court must determine whether there is sufficient evidence to establish the other crime or wrongs as fact. And number two, the trial court must determine whether the evidence of the other act would be relevant to a material and disputed issue concerning the crime charged other than propensity. Okay. I'm going down past those. Second, the court must conduct a balancing test under Rule 403 and determine whether the danger of unfair prejudice substantially outweighs the probative value of the evidence. And here's the discussion. The prosecution failed to provide reasonable notice. When the state initially moved to introduce the evidence under 404B, it offered vague generalities to the nature of the evidence. It listed the general nature of the evidence that it intended to present, including 27 listed categories of evidence related to Charles Vallow's death, Lori's previous husband's death, and other evidence. Mrs. Daybell objected based on the extensive sweep of the motion, and the district court tended to agree. All right. The state followed up with an amended motion to introduce the evidence, this time trimming the evidence in some ways, tied primarily to the matters regarding Mrs. Daybell's marriage trouble with Charles Vallow, the castings, the events leading up to and after Vallow's shooting death, and the attempted shooting of Brandon Bedreau. But it was still exceptionally broad. Mrs. Daybell again objected to the lack of reasonable notice, citing the broad scope of the evidence and the burden it would put on the defense to investigate what amounted to a separate case or cases in a different state for a trial that was set to begin in just a few short weeks. The district court overruled that objection, distinguishing cases where the Idaho Supreme Court had reversed for insufficient notice on the ground that the notice in those cases came at trial, if at all. The district court further concluded that because the nature of the evidence had been disclosed to the defense over time in discovery, the defense could not claim that it was a surprise. So she was not being ambushed. The district court abused its discretion in resolving the notice issued adversely to Mrs. Daybell. It is true that the state gave notice in advance of trial, but the question is whether that notice was reasonable. It was not. A requirement of reasonableness implies that notice is far enough in advance of a trial that the defendant has a fair opportunity to prepare and to meet the evidence. As such, reasonable must be assessed in light of the circumstances of the individual case before the district court. The case is unlike any other run-of-the-mill case that contains 404B issues. It spanned 2 states, was investigated by an alphabet of law enforcement agencies, featured intense and media scrutiny, had 2 precursor felony cases, involved 5 prosecuting attorneys and 2 defense counsels with a death penalty team, and was tried 3 years after Mrs. Daybell was arrested. The amount of information generated by so many individuals and entities was enormous. It is not reasonable to expect the defense counsel in a case such as this to read the prosecution's mind about whether it intended to introduce the uncharged misconduct from another state. This nature of this case and the amount of 404B evidence demanded notice much earlier than a few weeks before the criminal trial. As agreed by defense counsel below, there is no reason why the state could not have decided much earlier whether it intended to introduce the Arizona evidence. The state has been hiding the ball on this issue for at least a year and 8 months and 16 days. That's the time between the grand jury indictment and the time she was, the hearings. A reasonable conclusion is that it wanted the element of surprise, which is precisely what the notice of requirement from 404B is intended to avoid. This inference is bolstered by the state's repeated late discovery disclosure, which led the district court striking the death penalty as a sanction. The district court abused its discretion in not simply denying the state's amended motion for lack of reasonable notice. And number two, here's the evidence about this. Evidence is relevant if it has any tendency to make a fact or more or less probable than it would be without the evidence, or B, the fact of the consequences in determining the action under 401, the court allowed the state to introduce the bulk of the proffered Arizona evidence under the theory that it was relevant to prove plan, preparation, knowledge, or identity, which it claimed were disputed issues. Starting with identity, the Idaho Supreme Court has held that the evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. Okay. The quintessential example of when identity is a material factual issue, a prior bad act or crime tends to prove that the defendant is one who committed the crime, and is when there is a signature or a modus operandi apparent in the two crimes. On the other hand, when the characteristics of both the prior offenses and the charged offense are not in any way distinctive, but are similar to numerous other crimes committed by a person other than the defendant, no inference of identity can arise, cites the cases. It is true, for example, the state's theory that Charles Vallow was somehow lured into a trap and then shot under the guise of self-defense is in no way similar to the manner in which J.J., Tylee, or Tammy Daybell died. This also applies to about the factual circumstances of these events gives rise to the signature that tends to make the killer's identity more likely than without the evidence. More removed is how the circumstances of what the state has claimed were violent crimes in Arizona showed a signature that pointed to Lori Daybell. Knowledge. It also misapplied. For this factor to be relevant, the uncharged bad acts must logically tend to show an awareness or knowledge by the defendant of the charged crimes. The shooting of Charles Vallow and what the state contended was a setup for self-defense, and then attempted shooting of Brandon Bordeaux do not tend to make it more likely that Lori Daybell had knowledge of the murders of J.J., Tylee, or Tammy Daybell committed in entirely different ways. Perhaps the closest call would be defendant's plan or preparation, but the problem here is the state's shotgun approach to the 404B evidence. Some of the Arizona evidence under the state's theory of the case may tend to make the existence of a scheme or a plan involving the acts in Idaho more likely than without the evidence. But most of the prejudicial evidence, the circumstances surrounding the shooting of Charles Vallow and the attempted shooting of Brandon Bordeaux do nothing to move the needle, and as explained below, carried a high danger of unfair prejudice to Miss Daybell. Okay, this is number 3. Rule 403, balancing the probative value of the evidence was substantially outweighed by the danger of the unfair prejudice, confusion, and the issues and misleading of the jury. Okay. Even if there was some probative value from the Arizona evidence to one or more of the 404B factors, the danger of unfair prejudice was extreme. Circling back to where Ms. Daybell began this issue, the state's laundry list of 404B evidence from Arizona, where about 1/3 of the witnesses testified partially or entirely to what the state contended was criminal activity or bad acts in Arizona, meant that Ms. Daybell's trial was based to a large extent on the 404B evidence. The state was not relying on some discrete judgment of convictions with a few supporting facts sprinkled in. It was essentially also trying her for conspiracy for murder to her ex-husband and a conspiracy to murder for Brandon Bordeaux crimes for which she had not been convicted. The facts had not been established on either of those events, and this created many trials within this trial. The danger from prior bad acts evidence is that it allows juries to convict the defendant because they are bad persons or have had bad character rather than basing a verdict on the facts supporting the crimes charged. It heightens the risk that so much mud will be flung that a jury could decide that the defendant must have done it or done something wrong. It is risking confusing the issues. What is the purpose of this evidence as opposed to that evidence? Okay. And can easily mislead a jury. A trial court should use the care of a surgeon with a scalpel when considering admitting this type of evidence in this type of case, not a meat cleaver. This case was rife with wholesale evidence of bad acts and bad character from Arizona. The probative value of the evidence, if any, was substantially outweighed by the danger of unfair prejudice, confusion of the issues, and misleading of the jury. For any of these reasons, the district court abused its discretion in granting the state's motion and admitting the Arizona bad acts evidence as in this trial. The district court erred in denying Mrs. Daybell's motion to dismiss based on the violation of her statutory and constitutional rights to a speedy trial. And here we go. We are on page 62. Yay! Or 64. I think we're going to be able to finish it today. Yay! We can always talk about it later, but I just want to get it read. Okay, so introduction. There are perhaps few other cases in which the defendant has so forcefully demanded her right to a speedy trial. Miss Daybell repeated the refrain early and often. Yay. Oh, I'm so glad you got back in. Thank you. Glad to see you, Michelle. Okay, so she repeated this often. Okay, her counsel noted it frequently in hearings and filings. Miss Daybell moved to dismiss, claiming that her speedy trial rights were violated due to the 2-year delay between the state's filed indictment and when she was ultimately tried. The delay was beyond the 6 months required and the time frame generally contemplated by the Idaho Constitution and the Sixth Amendment. The district court erred in denying that motion, and this court should reverse. Here's the problem, though. Remember, she was incompetent. You can't go to trial if you're incompetent. So, that was a long part of it. I think it was 1 year and 10 months or something like that she was incompetent. I'd have to go back and look at that. But anyway, standard of review. Whether there was an infringement of defendant's rights to speedy trial present, a mixed question of law and fact, this court defers to the trial court's findings of fact is supported by substantial and competent evidence, but it exercises free review of the trial court's conclusion of law. Yeah, it was a long time. But what else did she expect, Criminal defendants are guaranteed the right to a speedy public trial under the Sixth Amendment and under Article 1, Section 13 of the Idaho Constitution. In Barker versus Wingo, the United States Supreme Court set out a 4-part balancing test, which Idaho courts apply to state constitutional claims to assess whether the defendant's constitutional right to a speedy trial has been violated. The factors to be considered are, number 1, the length of the delay, number 2, reason for the delay, number 3, the defendant's assertion of her right to a speedy trial, and the prejudice occasions by the delay. None of the 4 Barker factors is by itself either a necessary or sufficient condition to finding a deprivation of the rights of a speedy trial. Idaho also has chosen to supplement the constitutional rights with a statutory right to a speedy trial, and it states another one. The statutory provision give criminal defendants additional protection beyond what is required by the state and federal constitutions, and it starts citing Clark and something else. Under that statute, absent of good cause, the trial court must dismiss a prosecution against a defendant if, among other things, if a trial is not postponed upon her application, she is not brought to trial within 6 months from the date that the defendant was arraigned before the court in which the indictment was found. Hey, Magic Star, so good to see you. I'm reading that brief about the brief that that Lori Vallow's attorneys filed in her Idaho cases. So good to see you, Magic Star. I'm so glad you came in. We are on page 66 out of page 71. It's a lot of legal mumbo jumbo, but it is good. It's giving us information that we kind of thought we'd heard before, but we weren't sure. So anyway, The statute mandates that unless the state can demonstrate good cause for a delay greater than 6 months, the court must dismiss in the case, and it cites another case. Good cause means that there is a substantial reason that rises to the level of legal excuse for the delay. The good cause determination may take into account the factors listed in Barker and the surrounding circumstances. Okay, so it's citing these cases, and so let's see. I'm going to go past the citings. I'm just going to go down to, but if the delay has been a long one, or if the defendant has demanded a speedy trial or is prejudiced, a stronger reason is necessary to constitute good cause. The state filed its indictment on May 25th, 2021. Mrs. Daybell's trial started on April 3rd, 2023. Nearly 2 years since the state's indicted her. The Idaho Supreme Court held a 14-month delay since indictment's presumptive prejudicial state to, okay, this cites another case. Let's see. The 2-year delay in this case is presumptively prejudicial. In addition, the district court noted Lori has never waived her right to a speedy trial, and it's clear that she never relinquished or abandoned this right. Not only did she not relinquish the right, she loudly asserted she demanded a speedy trial at her arraignment. She objected to her counsel's request to reevaluate her competency on November of 2022. Okay. She moved the court to dismiss the indictment after it had reset the trial date for April of 2023. Her counsel also repeatedly indicated in statements to the court in their papers that their client was asserting her speedy trial rights. This factor weighs strongly in her favor. A portion of the delay is clearly attributable to the court's finding that Mrs. Daybell was not competent to proceed on subsequent restoration proceedings at the state hospital. The court found her incompetence on June 9th of 2021, staying her case, and then lifted this stay when it found that she was competent on April 11th of 2022. See that? I mean, that's let's see, 8 months or so, a period of 10 months while Mrs. Daybell concludes that the reason for her portion of the delay is not attributable to the state. It is not attributable to her voluntary choice to seek a delay either. At most, it's neutral. She was arraigned on April 22nd, 2022, and demanded the speedy trial, which was set the following October. The state quickly filed a motion to continue about 90 days to the next January to line up with Chad Daybell's currently scheduled trial. The court found good cause supporting this motion over Mrs. Daybell's objection, okay, to avoid an improper severance of the cases. Okay, so it talks about the case that they cited. In October, Mrs. Daybell's counsel filed a motion to stay the case and reevaluate her competency. They noted that she objected to the motion, and she also objected to the hearing. The court granted the motion and reset the trial for April 23. In November, the court held an evidentiary hearing and found Ms. Daybell competent. It lifted the stay of the trial to begin April the 3rd. The overall reasons for the delay, incompetency, placing the cases on the same track for trial, and reevaluating competency do not necessarily weigh in favor of either party. Mrs. Daybell personally did not request any of the delays, and she objected to them when she could. The final component of the analysis of prejudice, as noted, a 2-year delay that a defendant did not request or acquiesce, and presumptively and it was prejudicial. But the court must also look at the particular facts in the case before it. So then it states this other case. In Barker, the United States Supreme Court identified 3 interests that the right to a speedy trial is designated to protect: preventing oppressive pretrials, incarceration, minimizing anxiety and concern of the accused, and limiting the possibility that the defense will be impaired. When assessed the preventing of oppressive pretrial incarceration, Baker, the district court focused on the time between November and April. See, okay, it talks about this other case. But that is too small of a window of time. Mrs. Daybell had been incarcerated since her arrest in February of 2020, and she never left custody. True, she was not technically incarcerated on these particular charges until May of 2021, but a shift in the paperwork as the basis for holding one in jail hardly matters to the detainee. And while some of that time was spent in the state mental hospital, that too is but a different flavor of jail. The oppressive pretrial incarceration factor runs in tandem with anxiety and concern of the accused. The court may recall that until right before trial, the state was seeking the death sentence against Lori Daybell. The anxiety and concern of one awaiting trial for 2 years for a trial could result in sentence of death must understandably be immersed. As for limiting the possibility that the defense will be impaired, Mrs. Daybell acknowledges that her counsel voiced concern about what they thought was the shortness of time to prepare. Still, the right is personal to her, not to her counsel. Overall, in light of Mrs. Daybell's reported and strong invocation of her rights to a speedy trial, which reflects her strong desire to see the charges resolved and to avoid prolonged anxiety in an oppressive pretrial incarceration conditions, the presumptively prejudicial length of the delay balanced against the reasons given for extending the time, the district court erred in concluding that good cause had been shown to overcome the fundamental rights. The court should have instead dismissed the indictment under, the number, and erred in further concluding that Mrs. Daybell's Sixth Amendment right to a speedy trial had not been violated. This court should have reversed with instructions to dismiss the indictment. In conclusion, ding, 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 we're on page 71. No, we're on page 70. Lori Daybell respectfully asked the court to reverse her judgment of conviction and remand for an order dismissing all charges against her based on the violation of her statutory and constitutional right to a speedy trial. Short of that, the court should reverse the judgment, conviction, and remand for a new trial based on the errors raised in the issues 1 through 4. Respectively, submitted on the 30th day of May, 2025 by Craig H. Dunham, attorney for the appellate. Yay! All right. So we have managed to read the whole thing. Yay. Wow, that was big. Yeah, that was a lot of reading. Anyway, so I'm so glad y'all came and listened to me. I appreciate that so much. We've been on for almost 2 hours. That's a lot of reading and that's a lot of information. But it's not going to work. I mean, she's clearly not going to get a new trial based on that. It's just not going to happen, I know that she may think it is, but here's the thing. If she is like some kind of immortal or how does she put that? Some kind of being that, she should know everything that's going to happen, right? She uses religion for everything. She should know that she's not going to win this appeal. So why is she even filing it? I'm just joking. I'm just joking. I don't know. I shouldn't have said that. But anyway, yeah, she's really barking up the wrong tree on that kind of stuff. It's not going to work for her. Just not going to work. So any part of this that you missed, if you just want to go back and listen to it whenever you can, go ahead. It's just a bunch of information, just a bunch. So tomorrow, I'm going to actually get back on my Justin Banta case, which is the one with the Plan C pills. I'm going to tell you something. When I started watching this little movie that I bought, and I realized how easy this was and how it is not really regulated. Okay, number one, I didn't think you could send some kind of prescription pills in the mail, and this is prescription drugs, unless you were a pharmacy. This is not a pharmacy. To me, it seems completely illegal, but who am I, right? I'm just a person. I don't know. But there's just so many things about this. Just seems like in the wrong hands. Do you know, in the wrong hands, somebody could actually die from this. They really could. In fact, when this guy, Justin Banta, put this medicine in the lady's cookies and in her drink, fix this over here, and in her drink, he, how does he know if he put the right amount? He might have put too much in there. I mean, she could have overdosed. Who knows? I mean, it's really, anyway. Okay, so we've been here almost 2 hours, and I'm going to say goodbye for today. I really appreciate you all coming and listening. Thank you so much. It's just we are fixing to get rain. Yay, we are fixing to get rain. Did you say it was a form of narcotic? Well, let me tell you what Plan C drugs are. Okay, hang on a second. I got to go find this over here. Okay, wait a minute. Who's texting me? Oh, I can only. Hang on. All right, let me go see I'm going to tell you what these drugs are because it tells you in the movie what the drugs are. But, and they ship them to all 50 states. That's the weird thing about this. I was like, what do you mean you ship it to all 50 states? And it's like Plan C drugs. Hang on, let me get this to pull up for us. I'll tell you what this is. Okay. Here's what it is. If you are under 9 weeks pregnant, the starting dose is I'm sorry, I'm going to spell this out because I can't pronounce it. It's 1 MIFEPRISTONE pill and 4 MISOPROSTOL pills. So it's mifepristone and misoprostol, I think that's how you say it. So people who are more than 9 weeks pregnant often need additional pills, 8 to 12 pills total for your body to naturally, abort this child. Now, they mail them to every single state. How accurate is the pill? Well, you look how many pills you're taking. Of course, it's going to be accurate. I don't know how y'all feel about that. It's up to 98% effective. Let me ask you a question, though. If you are taking these pills as instructed, okay, and you're taking that many pills, and let's say that it doesn't work, what is it doing to that child? Is it safe? Are you then guaranteed to give birth to a child that's got mental defects or physical defects because you took these pills? I don't know. There's so much information we need to find out, because it is. I'm so shocked. And they say, okay, here's another question. Are Plan C pills legit? The combination, which is FDA approved for use up to 10 weeks of pregnancy, is 98% effective. Getting an abortion pill via a virtual clinic like Hey Jane is just as safe as effective as getting them in person. Okay? Wow. Listen to this. Is Plan C banned? I got all kinds of questions about this. Rain? Oh, we are going to get some rain. Thank goodness. Some states have banned abortion or created lots of restrictions, which means it can be hard or illegal to get the abortion pill in those states. But abortion is still legal in many states, and it's legal to travel to another state to get an abortion. Okay? I sure hope YouTube doesn't get upset, but here's the thing. Okay, Magic starts telling us what this is. It is typically used to prevent and treat ulcers from using stuff like oh, yeah. Okay. All right. I got you. Wow. Okay. So yeah, it says, okay, you can travel to another state. But let me see this. There was something I wanted to read y'all. Hang on a second. Does CVS sell this drug? We're currently dispensing that drug in our pharmacy in a select states where it's legally permissible. So it comes from whatever pharmacy that this is legal in, rather than a pharmacy that it's not legal in. Okay. So let me see. Let's tell you how expensive are these pills? Listen to this. The pills cost about $600 on average if you do not have a health insurance. Health insurance? Okay. Your out-of-pocket costs may be lower if this care is covered by your insurance plan. Abortion pills may not be available in your state through a telehealth professional. Okay. Now, let me see. There's something else I wanted to say. And it also goes in here to talk about how to stop a pregnancy after 3 months. Oh, my God. Stop it. Stop it. My God. Oh, but the movie is very interesting. And the movie is, it's a little bit of an older movie, but it's basically the same. It's what they're doing right now. It's the same thing they're doing right now. So anyway, I think y'all will really enjoy that. Yeah. Oh, it can be used to terminate. Yeah, that's exactly what they're doing. That's what the 2 bills that they're using right there, Magic Star. That's what they are. And so, but you'll see when I show this film tomorrow. And what I was going to do was, because it's such a controversial topic, and let me just say this ahead of time. I'm going to show all this, but these are not necessarily my views on it, because I don't judge people. It's not my right to judge people. I'm not going to tell you what you can and cannot do with your body. That's up to you. I live with this. It's your body, your decision. And everybody goes, well, are you Christian? Well, that has nothing to do with it. My beliefs and your beliefs can be different, and that's okay. And whether I believe it's okay or not is not my right to put on you, right? That's between me and my God, just like, whatever. So I thought about just doing this all pre-recorded, just, but do it in little series about this till I played the whole film. But then I thought to myself, People want to talk to you. They want to have these controversial discussions. They want to be heard. They want to hear other people's opinions. Knowing that not necessarily is your opinion going to be the same as somebody else's. So then I decided, you know what? I'm just going to do it live, and we're just going to go through it, and it's okay. We're just going to do it during the day because, I like to, and plus I have a lot of modding jobs that I do in the evenings for other creators, and I love doing that too because I can always talk to my friends. So I suppose the issue might arise from how it's used, like making others take it. Well, this is exactly what happened in Justin Banta's case. He slipped, because it's so easy to get, he slipped it in her drink and made cookies with it. Right. See, and then she wanted to keep this baby, but this guy is charged with capital murder here in the state of Texas because he was seen. It's on film. He's putting it in this drink at this coffee shop. It's on film. He can't deny he did that. So it's a very interesting case, and I'm going to follow that case all the way through. Even though I don't really do true crime, that's really not what I really wanted my channel to be about. But because of how this case worked out, and it comes back to he illegally, or he did this to her without her knowledge, and that is a psychological, it's horrible. It's sociopathic. I think it's sociopathic. But anyway, he made a decision for her that she did not want. She had already told him, no, I'm keeping this baby. The problem is he's married to somebody else. And the wife of this guy was telling, you better hurry and make that decision. Of course, she's upset. He was, he's catting around, got caught, got trapped, but he got caught because then anyway. But they had only been dating. He'd only been seeing this woman for about 30 days when he did this. When she found out, they've been seeing each other, I think it was like for 30 days or so, when she found out that she was, with child. So she had been to the doctor and found out that it was healthy. She had heard the heartbeat. Everything was good. And so it was about 6 weeks in, they went and met for coffee, and he was trying to talk her into doing this. And she was like, no, I don't want to do that. I'm keeping this baby. So he knew that he was going to meet her at the coffee shop, and he just decided, well, yeah, you're doing it, because he made sure that happened. So yeah, it's a horrible, horrible case. And I am going to follow it all the way through the trial, everything. I'm going to get all the documents. I'm going to get everything I can about this case. I find it to be just as horrific as if you took that person's child and you took its life when it was a newborn, whatever. It's the same thing to me. Because she wanted to keep that child. I get it, that was her right. That's absolutely her right. But anyway, so we'll talk about this tomorrow. I don't know what time I'm going to go live tomorrow. I'm probably going to, she was devastated. She absolutely was devastated, and I understand that. So we'll do this. We'll go ahead and do this tomorrow. I don't know. Do y'all want to do this about 1:30 or so? So we'll have longer. Is 2:00 good for you? What's a good time for you guys? I would do it noon. I think noon is a good time, but my good friend Magic Star, she don't get up that early. I know that. So I think, enable your notifications so that you can get notified. Let's just go ahead and we'll just do 2:00, because I know by then it's Central Standard Time, because I live in Texas. So it's 2:00 Central Standard Time. And I don't know what the difference is in between different states, between Eastern or whatever. Let me look at that. We'll look at it right quick. So if it's 2:00 in Central Standard Time, let's see what time it is. Okay, in Eastern Time. All right, hang on. Let's see. CST versus Eastern. What do you get? Converting. Okay. What time? Okay, if it's 2:00 CST. Okay, so Central Standard Time is 2 hours ahead of Eastern Time. Yes. So if it's 2:00 here, it's going to be noon there. Okay, because we're 2 hours ahead of the Eastern Time. 2 hours ahead of it. Yeah, that's what it is. So yes, I'm going to set it up for 2:00 here, and y'all get your notices on. So it'd be 12:00 for you, I think, Magic. Can you get up that early, Magic? Because the thing is, okay, listen, I am like a real housewife here. When my husband comes home from work at 5:00, the dinner's cooked and we're sitting down having our meal and all that. And so I make sure that no matter what I'm doing during the day, I do that too, because it's just something I've done my whole married life, and I don't know how to stop doing that. So yes, so we'll do that. Michelle, where are you at? You're in Arizona, right? Did you tell me you were in Arizona? Let's see. So I think y'all are 1 hour different in time, but let me make sure. Oh, no, Michelle's in New York. Oh, okay. So I think it will be, let's see. Hang on. Versus New York. Hang on. All right. So I think that Central Standard versus New York. What do we got here? Oh, God. Okay, hang on a minute. Let me do this. I missed. Well, you got to spell it right, stupid. You think it's 3 or 4 Magic Star? I think it's 2 hours. I think you're right about that. 2 hour CST. Mm-hmm. Is it 4 o'clock? Whoops. There we go. We should have all learned this in school, but hell, you can't remember everything. You know that. So 3 p.m. in New York is 2 p.m. Central Standard Time. So it'll be 3 p.m. for Michelle, and it'll be what did we decide it was? It'll be noon for Miss Magic Star. Okay, guys. So y'all got that. So it's 3 and noon, and I'm doing 2. So it's So it's 1 hour and then 2 hours. Yeah, that's great. Okay, so I'm gonna set that up. And we'll reconvene tomorrow and we'll talk about that. And so, like, if you're driving or whatever, you just want to re-listen to whatever you missed, that's cool, whatever you got to do. So, and I don't ever say this, but, I need to remember to say this to people. I need to remember to say, hey, y'all hit that thumbs up. Y'all never hear me say that, do you? I always forget, even though everybody already did already. So anyway, I'm gonna remind me to start doing that. And I also need to fix my mods because I noticed that some people that have wrenches are not showing up. And so I don't know if this has happened from me going to this other system because I finally, yes, Magic Star, I finally got rid of the StreamYard. I finally got rid of it. Yes. So anyway, we're struggling with our own time zone. It's funny, isn't it? It's absolutely funny. So anyway, I want to say goodbye because I can sit here and say 20 minutes and say goodbye because I just enjoy talking to you guys. Anyway, I'll see y'all tomorrow at 2 o'clock. Bye. Oh, Lord.